Dear learners, we shall be starting with the lecture on characteristics of partnership. So this lecture on characteristics of partnership has to be distinguished from the lectures on definition and essentials of partnership, because there we looked at the definition of partnership as provided under the Indian Partnership Act. However, the characteristics of a partnership are slightly different from the definition and essentials of partnership. So here we shall be looking at the form, structure and nature of partnership firm. While looking at the characteristics, we shall be through the lens of advantages and disadvantages of a partnership firm. So certain characteristics, after we've discussed them, will fall under the head of advantages, and certain characteristics under the head of disadvantages. So to give you an overview of the characteristics which we shall be discussing, first we will be examining the separate legal personality aspect of partnership business, then the aspect of limited and unlimited liability. Thirdly, we shall be looking at the separation or convergence of ownership and management. Fourthly, what are the restrictions on transferability of a partner's interest, comparing them with some other business organizations, namely a company. Then, how suited a partnership business is for raising of the finances for the business and its growth. And then on the aspect of perpetual succession of the partnership business. So we shall be taking up each of these characteristics in some detail. These characteristics have also been discussed in the nature of a company, but these characteristics may differ in the case of a company as compared to a partnership firm. Hence, this is a different discussion from that of a company. So taking up the legal personality first. So a partnership business has no independent legal personality of its own. So a firm has no legal existence independent of its partners. So a firm is regarded as accumulation of partners or a collection of partners. And so the legal status is that a partnership firm is not a separate legal person in the eyes of law, as in the case of a company or in the case of a limited liability partnership or a corporation. And so the business cannot belong to the partnership firm, rather it belongs to the partners. However, the business is run by the partners in the name of the firm. So a partnership firm is a collection of partners, and the name that is given by the partners to the collection of partners, that is a firm, it is known as a firm name. So therefore, because a partnership firm does not have a separate legal personality, so there is not much to discuss on this aspect. Then moving on to the second characteristic of unlimited liability. So a partnership firm has unlimited liability as distinguished from company and limited liability partnerships, which have limited liability for its partners and shareholders respectively. So unlimited liability here refers to the unlimited liability of the partners who constitute the firm. Now the basis of the unlimited liability of a partnership is provided under Section 25 of the Indian Partnership Act, which provides that every partner is liable. So here the liability is of a partner, jointly and severally. So we shall be examining this expression, joint and several, for all acts of the firm while he was or is a partner. So here you can see that there is a synonymization or equivalence of the acts of the firm as attributable to the acts of the partners. So for all actions of the firm, the liability, the consequences, the effects, they have to be borne by each and every partner. So this forms the basis of unlimited liability of a partnership firm. The effect of this provision is that the liability of the firm is equalized or manifested in the liability of the partners, because the firm is not a separate legal person, so liability cannot be attributed to someone who is not recognized as a person in the eyes of law. So there has to be somebody who has to bear that liability. Because firm is not a separate legal personality, so it cannot bear that liability. It has to be borne by somebody who is a legal person. So in case of a partnership, the liability of the firm is attributable to legal persons who are known as partners. The meaning of unlimited liability of partners is that their liability is personal and unlimited, which extends to their personal assets and belongings. Now, this extension to their personal assets and belongings, it arises in those cases where the debts of the firm have not been repaid back to the creditors, and looking at the state of finances and accounts of the firm, it is not possible for the firm to pay off its debts. So in that case, the creditor can lay a claim on the personal assets of the partners. The liability of the partners is not only unlimited and personal, it is also joint and several, which is another feature of a liability. So what it means is that each partner is individually liable for full debts as well as jointly liable for such debts. So here we have the word individually, which corresponds to the word several, and we have joint liability, which corresponds with the word joint. Now, what is joint liability? What is several liability? We will discuss in the subsequent slides in this lecture. The objective of having unlimited liability, personal liability, as well as joint and several liability is protection of the creditor who in good faith has given credit to the partnership firm. So the creditors can pursue their debts on any one of the partners individually or all the partners combined for the entire amount. Now, this benefit is given to the creditor of joint and several liability to ensure that their debt is paid off even if one partner is unable to pay his share. So in that case, the creditor can sue the other partners for the full amount if one of the partners is not able to pay his share of the debts to the creditor. Now let us examine joint and several liability with the help of an example. So we will first see a facts, then we will see based on those facts what is joint liability, what is several liability. So there is a partnership firm which consists of two partners A and B. The firm owes a total of 1 lakh rupees to a creditor C. Their joint liability means they are both responsible for the full 1 lakh together. So by joint liability, the creditor can sue them jointly for 1 lakh rupees, in which case the suit will be filed against both the partners A and B. But if one of the partners, let's say, runs away or becomes insolvent, then the creditor C can sue them individually for 1 lakh rupees. So this joint and several liability principle, it favors the creditor to sue for his debts because it empowers the creditor to pursue full payment if necessary from the partner with the deepest of pockets if the other partners cannot pay the debt that is due to such a creditor. So this is a benefit that the unlimited liability affords to the creditor, which goes a long way in reposing a lot of faith as well as trust in the creditor, because then he has this remedy of suing the partners individually or collectively. Now let us also examine from the basis of an exercise how does unlimited liability operate in case of a partnership firm. Supposing there are two partners, Raj and Aryan, in a firm X. So X is the firm name. The firm X, facing some financial difficulties, is undergoing the process of dissolution or closure. So on the date of settlement of the accounts, assets of firm X are 1 lakh rupees and its liabilities to the creditors are 5 lakh rupees. The difference is 4 lakhs. Now, because the business is undergoing financial difficulties, it will not be possible for this business to pay off the debts to the creditors. So the question is that how this 4 lakh rupees will be repaid to the creditor. Now the creditors of firm X make a claim against the houses of Raj and Aryan to recover the debt. So in case of unlimited liability, where the liability is personal of the partners, so the question is, will the creditors succeed in their action? So the answer to this question would be yes. So house is a kind of a personal asset, and in case of unlimited liability, the personal assets are at the risk of the partners. If it had been, instead of a firm, a company, then the claim of the creditors would not have succeeded, because there the personal assets of the shareholders, they remain protected from the business creditors of the company. Now we will further examine the aspect of unlimited liability from the point of view of two stakeholders, that is the partners as well as the creditors. The unlimited liability is favorable more to whom? The partners or the creditors? So we will first examine unlimited liability from the point of view of the partners. Supposing there is a firm Y and there is a person X who is a partner in firm Y. Now, if the business of the firm is successful, if the positive economic condition occurs, then in that case, the rewards which may be obtained by a partner, those rewards are kind of unlimited. There is no capping on how much of profit a partner can earn, subject to the law of the land and the taxes. So theoretically speaking, the prospect of reward is unlimited. Now, considering that the opposite economic situation occurs and the business faces financial distress and loss. So in that case, because here is a limited liability, now depending upon how much of liabilities the partnership firm has or the business has, the risk again is also unlimited. So it may be first satisfied through the assets of the partnership firm, but if it is unable to be satisfied merely on the basis of assets of the partnership firm, then the personal assets of the partners, they could also be subjected to recovery proceedings. So here, firm assets plus personal assets. And so that is why, depending upon the extent or the quantum of the liability, there is no limit that is prescribed by the law as to how much of risk and how much of the personal assets of the partners can be made subject to the proceedings that may be brought in by the creditor. So they could go on till the extent of insolvency or bankruptcy of the partner. So here there is a kind of a symmetry because the rewards are unlimited, the prospect of rewards as well as the chances of risk, they also remain unlimited. So here we find a symmetry. Now let us examine unlimited liability from the point of view of a creditor. So if let's say that a creditor has advanced a certain loan amount to a partnership firm at fixed rate of interest, so in that case his rewards would be limited, that is return of the principal amount plus the interest. Now if the opposite economic situation occurs, then in that case the risk of the creditor also is limited by the fact that firstly the loan amount that he has given is limited in amount, and the secondly, if the creditor is not able to claim back that loan amount from the business assets of the firm, so firstly he will lay a claim on the business assets. However, if his claim is not satisfied through the business assets, then he can lay a claim on the personal assets of the partners. So this personal assets of the partners, this gives an additional claim to a creditor in case of a unlimited liability as compared to a limited liability. So this privilege would not be available to a creditor if instead of a partnership firm, the business organization is a limited liability partnership or a company in which the partners and shareholders, they have limited liability. So therefore the unlimited liability of partners acts as a protective shield or hedges the creditor from the risks that are associated with the business. So here again, because the prospect of rewards as well as risks, they are finite, so here we again see a symmetry. So now let us summarize the unlimited liability from the point of view of partner and creditor. So if a positive economic situation occurs, then a partner has no limit on the returns, no limit on the profits, whereas a creditor has limit on the returns, that is the principal amount as well as the interest. But a partner has also no limit on the risk, whereas for a creditor there is protection of the risk. So here it is advantage to the partner, here it is advantage to the creditor as there is protection from risk, while here there is no protection from risk. The liability of the partner may extend to personal assets if the claim of the creditor is not satisfied from firm assets. Now the creditor can lay a claim on the personal assets of partners if liability of the partnership firm is unsatisfied from the firm assets. So again, this goes in favor of the creditor. So for a partnership firm, limited liability is attractive. So if the partners, they are looking for limited liability, then instead of registering their firm as general partnership under the Indian Partnership Act, they should register their firm as LLP or limited liability partnership. So to protect or to cater to partners' interest, limited liability is more suitable for them. However, in case of a creditor, unlimited liability is more suitable because they have the protection of risk by laying a claim on the personal assets of the partners. So because a partnership firm has unlimited liability, therefore it suits a creditor more. So here, all in all, the unlimited liability is more suitable to a creditor than to a partner. So if the partners are more dependent on credit or borrowed money in order to run their business, then a creditor is much more likely to advance credit to a business organization which has unlimited liability as compared to a business organization which has limited liability. Now let us examine another characteristic of a partnership, which is ownership management convergence. So what it means is that there is no strict separation of ownership of business as well as management of business. In case of a company, the ownership is with shareholders, the management is with board of directors. So the partners in partnership perform the dual role of being the owners as well as being legally responsible for managing the business, conducting the business, and ensuring compliances with the law. One provision is Section 9, which provides that it is the duty of the partners to carry on the business of a firm in a way which is to the greatest common advantage of all the partners. So here the partners have a duty to carry on the business. Apart from this, it is also a legal right of the partners to participate in the conduct of the business. Kindly refer to our discussion on the rights of the partners for more clarity on this. Now, the partners, they are accountable to each other for all the acts which they do in order to run the business of the partnership firm. Whereas in a company it is different. The board of directors, they are accountable to a separate set of stakeholders who are known as shareholders. So here there is a kind of a mutual accountability within a same category of persons, that is partners, whereas an accountability in a company is with a different set of stakeholders. Now, analyzing this feature of a partnership, it is practical and also suitable for small and professionally run businesses because the partners can devote a lot of time to the business. However, it is impractical for large diversified businesses because it will be difficult for the partners to devote so much of time and attention to so many diversification of businesses. So if the partners, they are not professionals, then they will have a problem in managing the business. So for example, if there is a partnership of firm of lawyers, let's say, and if the same firm also has a business of, let's say, mines and minerals. So lawyering is a different profession and having a business in mining is a different profession or a different nature of the business. So therefore, it will require a different professional expertise. Now they can hire managers, but then in partnership, the onus is greater for the partners to have a role in the conduct of the business, at least legally speaking. Whereas they could be detached in case of a company. So if I am a shareholder in 15 different companies, the nature of all the companies is different. One is pharmaceuticals, one is fast moving consumer goods, one is IT. I don't have to devote my time and energy in managing the business. So if the partners are not professionals in the area in which the partnership carries on business, it may pose a difficulty and challenge to the partners. However, the partners, because they are owners as well as legally they have a duty to manage the business, it brings in more sense of belonging in actually running the business and managing the business. So in a company, the board of directors, they are not the owners. So it is possible that they have a less sense of belonging with the business as compared to partners in a partnership firm. So as rational human beings, we are more likely to take better care of our own personal property than taking the care of somebody else's property. So because the business here belongs to the partners, so they have a more attachment and loyalty towards the business as compared to a company. Then transferability of partners' interest. So under the partnership deed or partnership agreement, there are certain restrictions that partners put in transferring their co-partners' shares to a third party. So partners' interest in the firm is not easily transferable. So transferability is again something that is different from tradability. So shares in a public company that is listed on the stock exchange, they are transferable as well as tradable because they are traded like a commodity, the stock exchange. But the transferability in case of a partnership firm of a partner's interest is more restricted. So the interest of the partner cannot be traded at a public platform like that of shares of a company. So the tradability in that sense, it is closed as compared to a company. So tradability of a partner's interest is more like in nature of a private company. Now, even if the partner transfer his interest to a third party, then the third party only gets limited rights. Now this limitation is put in through a provision that is section 29 of the Partnership Act. According to this provision, a transfer by a partner of his interest in the firm does not entitle the transferee to interfere in the conduct of the business or to require accounts or to inspect the books of the firm, but entitles the transferee only to receive the share of profits of the transferring partner. So the limitations that are put herein are limitations regarding the conduct of the business, limitation regarding his access to the accounts as well as the books of the firm, but the only right that he gets is a right to share the profits. So because a transferee gets limited rights, so it is a disinvest. This is a kind of a disincentive to buy any partner's interest. Now, opposite of this is true in case of a company, for example, because when a share is transferred, then all the bundle of rights that come with the shares, they are also transferred. So a shareholder gets many rights upon transfer, such as the right to dividends and also the right to participate in the meetings of the company, the right to vote on resolutions, so on and so forth. Now, looking at the analysis of this feature, the liquidity of a partner's interest in the partnership firm is less as compared to a share because it is difficult to sell it off or to realize because there are transfer restrictions. But from the point of view of the firm, it does give stability because if the partner had made an investment in the firm, then it is difficult for a partner to get his interest out. So it can be done only according to the terms of the agreement, which may require the consent of the other partners. So this is a kind of an advantage to the firm, but may be a disadvantage on the individual rights of persons who are partners. And so it leads to non-assignment of contracts, meaning thereby if a partner becomes a part of the partnership firm, then he has entered into a contract. But if he transfers his interest to a third party, then it will not automatically lead to assignment of that contract to a third party because of operation of section 29. Then on the raising of finances, the unlimited liability principle, as we have discussed, acts to the disadvantage of the partners because it exposes them to certain risks which are not there in case of limited liability. So the symmetry here is of rewards as well as risks, both of which may be unlimited. The membership of a partnership firm is again capped. Kindly refer to our discussion on the number of partners. So it is capped at a certain limit, that is 50. So they cannot bring in more partners beyond 50 if the firm requires more capital. So again, this poses a problem. Now looking at the analysis of this is, there is a problem in diversified partnerships because it is very difficult for partners to be a partner in different firms because there is a lot of management cost that is associated with being a partner in a partnership firm. So you have to do many of the legal compliances as well as you have to have a role in the management of the business. So therefore, if I as an individual can buy shares of 20 different companies, so I can be a investor in different companies, which is a source of capital for the company. But it will be difficult for me to be a partner in various partnership firms. So an investor is much more likely to invest in multiple companies as compared to multiple partnerships. The third is that because transferability is restricted, and so because of this, the mobility of capital from one partnership to another partnership is also restricted. So raising of finances is a challenge for a partnership firm as compared to some other legal entities like a company or limited liability partnership. Then a partnership firm has no perpetual succession because the life of the firm is linked to the life of its partners. So because it is not a separate legal person like a company, so the exit of a partner may disrupt the conduct of the business. Otherwise also, the dissolution of a firm is easier as compared to some other legal entities like a company or a limited liability partnership. So on the death of a partner, there may be a dissolution, or in case of insolvency of one or more partners, or in case of incapacity of partners, the partnership will come to an end. But this is not the case with, let's say, a company. So if there is perpetual succession, then the organization will not come to an end because of death, insolvency, or incapacity. So this no perpetual succession, it again is a kind of a disadvantage to the partnership firm because it poses certain risk to the partners, creditors, investors. Because then the life of the partnership firm in which the partners, creditors, and investors have a stake, it is more prone to be ended or terminated as compared to a company or a limited liability partnership. So therefore, it is a disincentive or an inhibition or a limitation for certain long-term investors who are more interested in the continued life of the business organization. So this perpetual succession again is a disadvantage for a partnership firm. So now, if we have to categorize our discussion in advantages and disadvantages of partnership, then first, the partnership has an advantage, that is ease in creation. So it is easy as compared to other forms of business organization like a company or limited liability partnership. So it can be brought into existence by drafting the partnership deed and entering into an agreement. Legally speaking, no other compliances are required related to registration, which are optional. The compliances of a partnership firm again are lesser in degree as compared to a limited liability partnership or a company. So for example, the partners do not need digital signature certificate or director identification number or registering on the portal, which is required in case of a company. So in that sense, partnership is more cost effective. The registration process is cheaper as compared to an LLP. The dissolution is also easier and does not involve many legal formalities. It can also lead to quick decision making as there is a convergence between ownership and management. Whereas in a company, there is a different set of owners and managers. So some decisions may require ownership approval. So it takes time. So all the decisions are taken by the partners together and they can be implemented easily because the partners are also vested with the authority to implement the decisions. And the partners, as being all powerful, they act on behalf of the firm. Then it brings a certain sense of ownership to the business because all the profits, they are shared by those who are working hard in the business. But in case of a company, the board of directors, they may be working very hard, but it is not necessary that they also become the shareholders. So of their hard work, the benefit may be going to the shareholders. But in case of a partnership, the shareholders, in case of a partnership, the partners themselves get the share of the profits. Now, disadvantages of the partnership firm, as we have discussed: unlimited liability, greater risk to the partners, no perpetual succession, a disincentive to long-term investors as well as creditors, limited resources because of limit on the number of members, no perpetual succession, and unlimited liability. So in that sense, it is difficult for a partnership to raise funds as compared to a company and an LLP. So now we will move towards the closure of this lecture on characteristics of a partnership. So we've discussed 6 of these characteristics, and we have, on the basis of our discussion on these characteristics, laid out the advantages and disadvantages of a partnership firm. So with this, we end the lecture on characteristics of partnership along with its advantages and disadvantages. Thank you very much.